An obsession with an elementary school student lands this former teacher of the year behind bars.
He has written my 11-year-old child over 60 notes just since June.
Now he could be facing years in prison. We'll take you inside this disturbing obsession. This is Inside the Crime, presented by Law&Crime. I'm Elizabeth Millner. Hey, by the way, there's a reason Law&Crime is the go-to spot for true crime content. Just like there's a reason Morgan & Morgan is America's largest personal injury law firm. They have more than 1,000 attorneys and have recovered $25 billion for more than 500,000 clients. In the past few months alone, a client in Florida received $12 million when insurance offered just $350,000. And in Pennsylvania, another client was awarded $26 million, 40 times the insurer's offer. Morgan & Morgan makes it so easy to fight for what you deserve. You can even start a claim from your phone. So if you're injured, you can start a claim at forthepeople.com/insidethecrime. Click the link below or scan the QR code on your screen. The victim's mom previously told a South Carolina judge this teacher didn't stop at just writing the little girl letters. He also showed up to her sports games, even to her church.
My child has had to endure moments of uncomfortability in places like church, school, and sports.
That was the victim's mom speaking in front of an Anderson County judge, emotionally sharing everything her 11-year-old child has been through. So how did someone who was once crowned Teacher of the Year end up arrested? Let's start from the beginning. 27-year-old Dylan Dukes was a music teacher at Star Elementary School. According to the Star Elementary School website, which has since been scrubbed, the school once touted the educator when he was named the 2023-2024 Star Elementary School Teacher of the Year. The school said Mr. Dukes goes above and beyond for his students. Obviously, in light of the allegations he faced, he's no longer a teacher there. But here's what police say happened late last summer. Detectives were informed on July 8th of 2024 that the music teacher had sent more than 5 dozen love letters to an 11-year-old former student. That's more than 60 letters. Officials say before the kids were set to go on summer break last year, Dylan made the 11-year-old a personalized box with a letter for each day of the week during summer break. He even showered the girl with gifts, giving her cards, gift cards, ornaments, pictures, and unwanted hugs, which made the young student feel uncomfortable. Detectives searched Dylan's classroom and found many photos of the 11-year-old child in his desk. According to the Anderson County Sheriff's Office, though, those photos were not sexual in nature. He was charged with stalking. When he appeared in front of an Anderson County judge for a bond hearing, he was still wearing his Star Elementary School t-shirt. During the hearing, the judge heard from the victim's mom, who detailed what her child went through.
He attended my child's functions outside of school, and he started attending our church. I've now realized that this access to my child had continued to grow his obsession. He has written my 11-year-old child over 60 notes just since June. Notes that talk about how amazing my child is and how much he loves them. And I agree, my child is amazing. My child is so sweet and innocent. And wants to ensure that no other children experience the stress and fear that they have. My child has had to endure moments of uncomfortability in places like church, school, and sports. Where my child should be comfortable and able to enjoy being a child. My child has had to be handed love notes from an adult male countless times. We have feared for our child's safety and for their own mental health. He has completely taken our family for fools, but our child will not be uncomfortable any longer. We ask that the seriousness of this situation is considered for our child's safety. We pray Dylan gets the help he needs so that this never happens to another innocent child.
First, I'd like to express my appreciation to everyone who was involved in this case. The urgency and seriousness has not gone unnoticed. As a husband and father, it is my responsibility to ensure the safety and well-being of my family. Given Mr. Duke's unrestricted access to our family over the years and the unknown intentions of his obsession, I cannot feel secure in knowing that he is not going to put my family in danger. I ask you to consider this in any decision that is made today.
Ms. Davis, you speaking for the family? or Mr. Dukes?
Yes, Your Honor.
Okay, go ahead.
Your Honor, my client is raised here in Anderson County. He went to T.L. Hanna High School. He graduated in 2019 from USC with a degree in education. He received Teacher of the Year last year, and one of the benefits of being Teacher of the Year is that you don't have to participate, you don't have to do your morning duty. He's the type of guy that still did morning duty, even though that's a dreaded job of most of the teachers there. Mr. Dukes his family's from here. His dad and brother actually were also here with his mom this morning, thinking there might be a bond hearing this morning. They were not able to be here this afternoon, but his mother's here. No question, he will report any time that is required. I have no doubt that he will abide by everything that I tell him to do. He will have no contact whatsoever with the child or her family. I would ask the court this is not the time for punishment. This is to make sure that he reports to court when he's required to, and that he not have any contact with the family and the child in this case, and he absolutely will not. He lives here in Anderson County. His mom lives in Pendleton, and he'll abide by any conditions or terms the court sets for him. And I would ask the court to set a reasonable bond. I would ask for a PR bond, but I understand if the court requires a surety, but the family does not have great means. They would have a really tough time making any kind of substantial surety bond. And I think that a low surety bond or PR bond will absolutely ensure that he will report for court when he needs to.
All right, anyone else? Okay. And you're going to advise Mr. Dukes not to make any statement at this time, correct?
Yes, Your Honor.
Okay. All right, Mr. Dukes, you'll have the following bond conditions. You are to have no contact with the victim or her family. That includes attempting to contact her, have others contact her or her family on your behalf. You understand the no contact order?
Yes, sir.
All right, based on the charges, I'm going to set this as a $50,000 surety bond that you will have to have posted prior to being released. You can either have a bail bondsman post that for you, or you can have someone post a cash bond in that amount, which would be held and returned to them once the case is disposed of, or you can have someone post a lien against real property in Anderson County. Do you have any questions on how to post your bond?
No, sir.
Thank you.
Your Honor, would that be a 10% cash or the full?
No, it'd be the full amount, no 10%.
Thank you.
All right, thank you.
Like I mentioned, after the allegations came to light, Dillon was suspended from his role as a teacher in the state of South Carolina. In a statement, the superintendent wrote, "This week, Anderson 3 was contacted by the Anderson County Sheriff's Office and made aware of an investigation involving a teacher at Star Elementary School. Upon learning of the investigation, the teacher was placed on administrative leave in accordance of our district policies. The district is fully cooperating with law enforcement in their investigation. Counseling services and additional support are available to any students or staff who may need assistance." But this is what the South Carolina Board of Education said during his disciplinary action. The State Board of Education considered this matter on July 12, 2024. In accordance with SC Code Ann and the State Board Rule of Governance, the South Carolina Department of Education requested that the chair of the State Board summarily suspend the educator certificate of Dillon Robert Dukes as a result of his arrest for the felony charge of stalking. The SCDE has reason to believe that due to the serious nature of these allegations of misconduct, Mr. Dukes may pose a threat to the health, safety, and welfare of students who may be under his instruction, and that emergency action is required. After considering the evidence presented by the SCDE, the chair of the State Board finds that Mr. Dukes' educator certificate shall be summarily suspended until a due process hearing is held and/or this matter is otherwise resolved. The SCDE is directed to serve notice on Mr. Dukes of the summary suspension, as well as the possible suspension or revocation of his educator certificate. So that was filed just days after his arrest. Dillon later posted the $50,000 bond and has been free from custody since. Just last week, though, Dillon Dukes made a shocking announcement. He was going to plead guilty. So in avoiding trial, he pleaded guilty to first-degree harassment. That guilty plea still comes with prison time. Last week, he was sentenced to 3 years of incarceration. But here's the twist. That sentence was suspended to 5 years of probation, meaning he's not going to prison unless he violates the rules of his probation. Civil litigation attorney Chris Klotch joins me now. And Chris, thank you so much for being here. But I got to ask, what's your reaction to this sentence? 3 years of incarceration, but suspended to 5 years of probation.
So it's not uncommon to see somebody that has no prior criminal history, and I would expect, since that Mr. Dukes was a teacher, that he had already had a background check, and so unlikely that he has any prior criminal history. I would have expected a much different outcome if there had been any type of pictures that, for instance, they said they found pictures in his desk, but they were not of any type of inappropriate nature, other than him possessing an inordinate amount of pictures of a child that was in his classroom. But frequently you see courts giving some grace to people who don't have any prior criminal history.
And in your opinion, do you think the judge should have been harsher? Because it feels like, the sentence was what it was because there was no sexual contact. But what are your thoughts?
So judges are always in a tough position because they've got to, weigh all of the facts. And again, just in this particular case, there wasn't any violent contact. There wasn't any contact that was reported that was sexual. I know that they said that there were love letters, so I don't know exactly what that included. I don't have any information about what was actually in the content of the letters, but I'm sure the court considered those. Should he have had a stiffer sentence? It's really hard to second guess a judge when they've got all the information. It is surprising though that it's seems to be only a probationary sentence. I know that there was a component of some type of maybe counseling that was involved with that, so maybe that'll help, because this is a pretty extreme case where you see a teacher having that type of contact and stalking of a child in his class, or really whether it was in his class or not, it's still inappropriate.
Yeah, and it's very disturbing too when we think about it, because I think, one thing that stands out to me in terms of this story is one, that being the 6 love letters that were allegedly written by Dylan Dukes that were given to an 11-year-old, as well as, gift cards and him showing up to her sports events and also showing up to her church. It really is a lot of disturbing behavior. And do you think it's possible that the family could make civil claims against him, or do you think it's possible that could even extend towards the school?
So if there has been any type of negligence on the part of the school district in vetting him to see whether or not there was any propensity towards inappropriate conduct, that's always something that a civil lawyer could take a look at and see. You'd have to have a little bit more facts to know what his prior history was. For instance, if he had been fired from other jobs for similar contact or conduct, and then they had not vetted him thoroughly to make sure that he was going to be a safe hire, sure, there could be some type of lawsuit perhaps. Obviously there has been emotional injury to the child. That is evident from the court proceedings that have been talked about in the press, and so there is an injury, right? And then there is a duty of the school to make sure that its teachers are not doing inappropriate things with children. So it all depends on what the school knew about him, what they knew what was going on, whether he had any prior type of irregular or inappropriate behavior.
And I think it's interesting, and what I commend about this little girl coming forward is that she knew something was wrong. She knew that this behavior wasn't normal, and she told her family about this. And I can't imagine what it's like even being in her shoes. In your opinion, how important is it that the child did express fear that the behavior could become physical, because I know she definitely expressed on the fact that she was given unwanted hugs, plus the gifts, plus the letters on top of that.
That's a really good point, and credit to her family for making her feel comfortable enough to come forward and talk about it with them. You see cases where children don't report inappropriate conduct like this until they get to be adults, and they realize, oh my goodness, when this happened when I was a child, it was terribly wrong. And sometimes parents don't really encourage their children to, talk about things that are hard to talk about. So kudos to this family for having the type of relationship with their child where the child felt comfortable coming to them and saying, hey, this doesn't feel right. And I would always encourage, anytime a family has got young children, have those conversations early and often with them about empowering them to come forward and say, hey, something's happened to me that just doesn't feel right. I may not be able to say exactly what it is, but this has happened. And so empowering your children to have open conversations with parents is key. And fortunately, it seems like that happened in this case.
Yeah. And in your opinion, because I think about these letters specifically in terms of what type of response was he hoping to get from an 11-year-old girl? Because I'm thinking in terms of just the behavior that it could have escalated to possibly him inappropriately touching her or anything of that sort. But do you think that the behavior would have continued had the girl not said anything to her family?
So in most cases that I've seen like this in the past, somebody that is an older, whether it's a man or a woman, because I've actually seen these cases happen with male teachers and female teachers in the past. Right. The conduct, unless it is brought into check somehow, will usually escalate from what I have seen. Gratefully, in this case, there was physical contact. I mean, she did describe that she had unwanted hugs, but gratefully, that's bad enough by itself, but gratefully there was nothing even more, damaging than that. That by itself, when a child perceives something like that, even something as simple as an inappropriate hug can be traumatic. Okay. And so I don't want to discount that it was just a hug, but gratefully there wasn't any reported sexual contact. But yeah, the answer to your question is that in these cases where you have somebody who is age inappropriate, unless their behavior is checked somehow, then you can usually almost bank on an escalation.
And say, for instance, and we don't necessarily know this, but say, for instance, the family is displeased with the sentence that he was just given. Do you think that there are any types of tools or protections that are available to families when they do feel that the criminal sentence is a little too lenient?
So the state attorney's office is for practical purpose the representative of the family and the representative of the people overall in these cases. And so if a state attorney representing the people and also obviously the family and the child in this case feels that the sentence is inappropriate, they can file an appeal of that. That's rare, and it's usually very much of a long shot. So as far as any type of adjustment in the criminal case, probably unlikely. But they did actually hold over his head, from what I read about, a 3-year suspended sentence. And I can expect that if there's any type of violation of this man's probation, that if he does not follow everything to the letter of the law of what he is supposed to do, which appears to be counseling, there's also a restraining order preventing him from having any contact outside of the probationary conditions. I would expect if there's any violation, the judge is probably going to hammer this teacher.
In addition to, I think he had to turn over his teaching certification as well. And, Chris, I'm interested to know if the family does pursue civil action against Dylan Dukes, does the criminal guilty plea, does that impact the case at all? We don't know if they have filed a civil claim yet, but if they were to do so, does the guilty plea change anything?
So I wasn't present at the guilty plea, but generally guilty pleas require the person in court to admit to the conduct in front of the judge, and that's on the record. And so if there is an admission of the conduct on the record, then his statements in court could be used in a civil case. It's not always the case, we know just from famous past cases, just because of a criminal outcome doesn't necessarily determine what's going to happen in a civil case. But if he has made any statements or admissions in the course of entering his plea, then those could be something that could be used in evaluating and perhaps pursuing a civil case.
And as far as the plea goes, we do know it's for first-degree harassment, but do you think it should have been for a more severe charge as opposed to harassment? Maybe it should have been for stalking or inappropriate contact, something of that sort. But are you surprised it just ultimately ended up being harassment?
Well, that is probably a product of, I read that the initial charges were for stalking, and then I don't know if in this jurisdiction in South Carolina that if the harassment is a lesser included, but it was a first degree, and he was given a suspended sentence of 3 years, which suggests that's a pretty high level. If that's a pretty high level, if that's a misdemeanor, that would be unusually high. I don't know in South Carolina if that can rise to a felony, perhaps, which may explain the 3-year sentence. But frequently what you see for people who have no prior criminal history, it sounds like there was probably an element of plea negotiation between the lawyer that represented him and between the state attorney's office if the charge was reduced from a stalking to a first-degree harassment.
And that's what we normally see in these cases, that normally defendants end up pleading to a lesser, partially because it's a lesser sentence, but also to avoid trial too. And in the possible future, if there were new evidence, if new evidence were to emerge in this case, under what circumstances could this criminal case possibly be reopened or new charges possibly be filed? For example, if there were more students who ended up coming forward.
Yeah, so that's a really good point. And I didn't see anything that indicated that the law enforcement had served a search warrant on perhaps his phone or his computer, but I'm quite sure probably something like that, happened in the normal course of an investigation. And so if that has happened and they do find perhaps maybe some sexually inappropriate photographs of this young woman or any other children, you can bet that the state attorney is probably going to come back and charge him with a new crime. I would be surprised if they didn't do that prior to the disposition of this case with this plea, but sometimes it takes a week, 2 weeks. It can take as long as a month or two to do a forensic search of a phone or a computer. But I can almost guarantee you that if there's any inappropriate photographs or any other contact with children, he will probably not receive such a light treatment.
And how, in terms of this case overall, if someone were to come forward, maybe not necessarily now, but years later, how does that change anything? I mean, we've seen this before where victims have come forward later on and they report what had happened to them. And I know for what we do know about Dylan Dukes' background, that he was at the school for about 4 years. He was a music teacher. So for instance, if someone were to come forward later on, years down the line, is it harder to prosecute that type of case? Is it easier? What are your thoughts overall if that were to be the case?
Yeah, the older cases, the harder it is for a prosecutor to pursue. There are statute of limitations, and I'm sure that South Carolina has some statute of limitations regarding different types of crimes against children. If they're misdemeanors, they could be shorter. If they're felony charges, they can be longer. But it usually does make a case harder to pursue criminally the older the case gets. So it's important, if there's anything out there, that hopefully law enforcement has done a thorough search of his private computer and his phone and any of his school software that he may have had to see if there was anything inappropriate there. Doesn't mean it's impossible. They can certainly come back later if they find some evidence on down the road, but it is usually better to pursue them as quickly as possible.
And Chris Klotz, my final question to you is, do you think that Dylan Dukes, I know you don't know him personally or anything like that, but do you think that he can follow the rules in terms of his probation to keep him out of trouble these next few years?
That's a tough question to answer, because I have actually seen, in my experience, I've seen some people who have been sentenced criminally and they've done very well on probation. And they've gone to therapy and they've had counseling and they've actually gone on to have successful, crime-free lives. I've also seen some people who have a mental health issue, because generally when an adult is acting like this with a child, there's generally some type of mental health issue there, right? Or some type of reason why they have this inappropriate attraction to children. And if that's the case, then he's going to end up getting more trouble. If he's able to get it together and try to get some help to address the issues that are making him have absolutely totally inappropriate, connections with age inappropriate people, then, it's going to be a hard road for him.
Yeah. Well, Chris Klotz, I want to thank you so much for joining me and for your analysis into this case. I really appreciate your time today.
Always a pleasure.
According to Fox Carolina, Dylan Dukes' terms of probation also include him surrendering his teacher certification, he must undergo mental health counseling, and he must comply with the permanent restraining order barring him from contacting the young girl or her family. Thanks for tuning into this episode of Inside the Crime. I'm Elizabeth Millner.